Today we're going to be talking about contracts. Some people think that that's a bad word, because in some cultures and some age groups, everything's done with a handshake, and that's fine. I don't have a problem with that. The problem, though, is that you might have a problem with it. You see that a handshake deal shows trust. It shows that you are okay with the other person and you don't want to offend them. I get that. However, when something goes sideways, let's say that one of you forgets what you agreed to. Well, who's in the right? How do you prove what you agreed to? It's not necessarily a sign of distrust to have a written agreement, to have a contract. Instead, it can be something that evidences what your agreement is. It shows what your expectations are. It shows what your promises are, what you can rely on, and what you can remind yourself of. These are all great benefits of having a written contract. Not to mention the fact that if something goes south, where you have to enforce those promises, where you have to say, hey, you didn't fulfill your promises, where expectations were not met, you need a written contract to be able to enforce it. That way you can bring it to court. You can show it even to the other party and say, here's where you signed. Here's where you agreed to do A, B, C, and D. Let's get into the specifics, though. There are contracts with all sorts of different people for your business. Your business should have a contract between the owners of your business. If it's a corporation, that would be bylaws. If it's an LLC, it would be an operating agreement. That's a contract that shows what the rights, responsibilities, and expectations are of the owners of the company. But you should also have written contracts for investors in your company. Or if you take on a loan on behalf of the company, that should be written down. If you are extending a loan, that should be written down. Why? Let's talk about those agreements. It's going to talk about what the payment terms are. Are you paying a monthly amount? And if so, for how long? Are you paying it all off through those monthly payments, or is there some balloon payment at a set time? What is the interest rate of that loan? These are all things that, when written down, you can remind yourself of them. Is there a grace period where, normally payments are due on the first of the month, but it's not a default if they're received within the first 5 days of the month? These terms are important so that people can rely on them. You can rely on them if you're making the payments, and you can rely on them if you're receiving the payments. You should also look at where else your company could use contracts. What about employment contracts? In Michigan, like most other places, most employees are at will. That means that they can quit whenever they'd like, and you can fire them whenever you'd like, assuming you're not firing them for an inappropriate purpose. Well, they can still have a contract. What would that contract say? Well, it would say that they're at will. Great. It would also talk about what their pay is, how much time off they have, when they're eligible for fringe benefits or health insurance. It spells out their responsibilities. Now, we have to be careful, though. When dealing with an employee, you are not giving them the freedom to do whatever they'd like. You are actually telling them what you would like them to do. You are directing their actions. On the flip side, an independent contractor is free to do the work that needs to be done in the way that they determine how to do it. And in a contract with an independent contractor should say that. It should specify that they're an independent contractor, that they are being hired to do a job, but that they are free to come and go as they please, and they are free to use their own equipment, have their own insurance, etc., because they are independent. You are not in charge of the ins and outs of how they do their job. By having a contract, it helps avoid those issues. What if you're paying someone as an independent contractor under a 1099 and you're not paying their taxes and their withholding, but they claim that they're an employee and you should have been withholding those taxes? Well, there's big penalties if it turns out that they were an employee and you weren't paying the withholding taxes. Well, having a good written contract helps, because now you can show not only did you not direct their actions, but you have a written contract where they agreed to have their own insurance. They agreed to have their own schedule. The timing of the contract is much more open-ended. Please paint my house by X date. You're not saying come Monday through Friday, 8 to 5. You're saying just get it done. These are important pieces that we can talk about later if you need such a contract. Where are other areas where your business needs a contract? Well, most all of you have leases on the building in which your business operates. Well, that lease is a contract. That lease is an agreement between your business and the landlord that spells out how long you're going to be there. Can it be renewed at the end of the term for a longer period of time? How much are you paying? Can they increase the rent during the term of the lease or not? What is the interest rate? Do you have a grace period? In most commercial leases, the windows on the business are the responsibility of the tenant. Meanwhile, the furnace and the roof and the walls are the responsibility of the landlord. These are things that are normally spelled out in a commercial lease. It's important that you know what your responsibilities are, whether you're the landlord or the tenant. That way, if something needs to be fixed, whose responsibility is it? In most commercial leases, the furnace, for example, is a responsibility of the landlord, but the tenant is responsible for the annual maintenance of the furnace, or the first $1,000 of maintenance on the furnace per year, something like that. These terms allow the parties to know what to budget throughout the year. It probably also talks about how much insurance the tenant needs to maintain on the property. That way, if there's a fire or something, the landlord is protected. Well, how much is that insurance? These are terms that are negotiated at the beginning of a lease. Other areas where contracts are used, let's talk about your suppliers. Are you buying a certain product for your business routinely? Do you have some contract that shows how much of that product you are getting each month, each week, each day? How much you're paying per pound or per shipment? These things allow your business to budget and to look long term, to begin planning for expansion and growth, because you know that you have this supplier on a contract and that you can rely on those shipments on whatever schedule you've agreed to. Same with your customers. Do you have contracts with your customers? Something written down where they agree that they will continue to buy from you for months and years into the future, or that the prices are set so that you can rely and budget on their purchases. These contracts allow you to plan. There are many times where that contract would become beneficial and monetarily good for you. Let's say you want to sell your business. If you have contracts with your customers and can show that you have $1 million of revenue coming in each year because these different customers have all agreed to buy from you, well, all of a sudden that is an asset that can be sold with your business. If, on the other hand, it's only handshakes, that becomes a problem. How can you guarantee that someone buying your business would also have the same customers? Would the customers stay with the new owner? Would the customers pay the same amount to the new owner? There's no guarantee and there's no proof that they would. These are some of the areas in which contracts are beneficial. Of course, there are dozens, if not hundreds, of different types of contracts. I'd be happy to help you with each and every one of them. The basis, though, is that you need to have the contract written down. If you want the contract to be enforceable against someone, that person or that company needs to sign the contract. A contract is not enforceable against a party who hasn't agreed to it. These are important pieces. The contract should spell out where the contract is enforceable. Here in Michigan, if your business is based in Michigan, you probably want your contract based in Michigan too. I did have a client a number of years ago who wanted to enforce a non-competition agreement against one of her employees. Her employee literally left the business, went across the street, and started competing. This was here in Michigan. The employee had gone maybe 200 yards, clearly was competing. However, the non-competition agreement that they had both signed, my client had apparently gotten off the internet, and that non-competition agreement had to be prosecuted in the state of Tennessee. Now, it made very little sense for this Michigan company to sue a Michigan resident for competition in Michigan in a court located in Tennessee. They had to decide whether it was worth going to Tennessee to file this lawsuit or just let the employee compete. Unfortunately, my client decided to let the employee compete because it didn't make economic sense based upon the contract that they had signed. I share that story with you because it highlights one piece of a contract. There are other pieces. Many contracts talk about arbitration clauses. Well, have you looked at what arbitration actually is? Arbitration can be very good, but it can also be rather expensive. Let's talk about it. If you were to have a contract breached that you had to enforce and you went to court, court normally has relatively few fees associated with it. The filing fee for a lawsuit could be, let's say, $175, $200, right? To file a motion is $20. A process server is $30 to $50. These are not big costs. And your case gets assigned to a judge, and the judge decides your case and manages your case among several other 100 cases. And therefore, you will get resolutions sometime in 8 to 24 months. It's not a quick process, but it does tend to work, and the costs are relatively low. However, AAA arbitration, the American Arbitration Association, is listed on many contracts as the way that the contract will be enforced or resolved upon dispute. AAA arbitration The filing fee alone is over $3,000. The arbitrators, especially if there's a panel of 3, each of them gets paid several $100s per hour. Now, granted, that cost is split between the parties to the arbitration, but I was recently in an arbitration and each party had to pay arbitrator fees over $60,000 each party. Now, arbitration can be much quicker. The arbitrators can set a schedule with briefs and a hearing within several months. So all of a sudden, you go from 8 to 24 months down to 3 to 6 months for resolution. That can be very advantageous. However, the costs could be prohibitive. So before you sign contracts with arbitration as the means of dispute resolution, you may want to consider, are you in a position to pay such arbitration fees? Otherwise, you may be better going to court. It's something to consider. These contracts have long-lasting effects. I've talked about how a purchaser may want to rely on the contracts, how you can rely on the contracts, how you can budget. But let's also talk about how you can scale your business. And we'll go into this in another chapter, but scaling your business is this idea of exponential growth, of figuring out how to brand your business, how to finance your business, how to grow your business beyond where it is now. One of the ways, or one of the aspects of scaling your business, is being able to look at your business and monetize it. Look at how your business is doing now, what contracts it has, and therefore, are you in a position to open a second location, to hire more employees? Are you in a position to grow your business because you can rely on the income of these contracts? Now, a contract is not a guarantee, right? Because businesses fail daily. But it gives you a whole lot more confidence than simply a one-off purchase. It allows you to begin thinking that you can grow that business, that if you had twice as many employees, could you provide twice as many services, twice as many goods? This is where contracts can benefit you greatly. The other areas where contracts are routinely done is somewhere with buy-sell agreements, with exchanging assets of businesses. This is very similar to other areas that I've talked about today. But again, it's all about the rights, responsibilities, and expectations of the parties. Please remember that most of the time when you're negotiating these contracts, lots of the terms are negotiable. Here at the law firm, we help negotiate a lot of contracts, helping business owners get the biggest benefit from the contract, and realizing that sometimes you have to think outside the box. Sometimes it is less important how much is paid per month, as long as the end amount is advantageous. Or to think about it that sometimes it makes more sense to pay off a loan or a purchase faster, because who knows what's going to happen over the course of time. So having a prepayment penalty in a contract doesn't really make sense. You may want to be able to pay it off early. If we look at the economy over the last 5 years, it has gone up and down quite a bit. And when times were good, it would have been good to have a contract that you could pay off early. These are areas where contract negotiation can be very important, where we can look at what's important to you and your business and how to memorialize that in a contract. I look forward to helping you. Please contact us with any questions. Ian Rudman with the Law Offices of Barton Morris.